Hey everyone, thank you very much for joining us. And today we actually have Gosha Sekhon with us. And Gosha Sekhon is a trust and estate practitioner. And Gosha's firm, Sekhon Legal Services, focuses exclusively on estate planning law. And she's been in the trust and estate industry for over 15 years and has extensive experience with planning involving incapable beneficiaries, small business interests, and blended families. Gosha is an '03 graduate of Queen's Law School and was called to the bar in Ontario in 2004. She currently lives in Oakville, Ontario with her husband and two children. Welcome, Gosha.
Thanks for having me.
No worries. Thank you for taking the time to join us. And so today we're going to do a quick dive into wills and just have a quick overview and understand the importance of it. So just to start off, to keep it quick, the first question is, why is it important to have a will?
In Ontario, and a lot of people don't realize this, if you don't have a will, we have a legislation, the Succession Law Reform Act, and that actually determines how your assets are going to be distributed on death if you don't have a will. And there's a set formula in there. So just as a simple example, if you are an individual who's married and have two children, the formula under this act states that your spouse first gets a lump sum amount out of the value of your estate, and then the balance is divided equally between your spouse and the two children. So that's the sort of approach that the Act has, and depending on who your surviving relatives are, then it will determine who gets what amount out of the estate.
Well, what kind of complications can arise if you don't have a will? Like, what kind of power do you lose in that case?
So if I was going to keep on with that example that I started with a couple with two children and one of the parents has passed away, a complication that can arise, for instance, is if you have children that are minors. So what would happen under the legal requirements for that is the share for the minor children is actually held in the Ontario courts until they turn 18. And this can be an issue for the surviving spouse because they would have to apply to the court to access the funds on behalf of the kids. And they may be in a situation where they don't have enough funds available to them for ongoing costs for running the household, and they have to consistently go to the courts to ask for that money. Another example of a complication that can arise without a will is, let's say that you are somebody who's not married, don't have kids, and you pass away without a will and you're survived by your parents. There are going to be complexities that arise, potentially unrelated, unnecessary costs, unexpected results because of that. Because if you are survived by your parents, they're going to get equally what you have left behind. The question arises, well, what if you're estranged from one of your parents or both of them? Or, an example that I've come across is one where a child is raised by divorced parents, and possibly one of the parents has played a bigger role in their life, given more financial support over time, and they may not necessarily have wanted the other parent to benefit on their death, but that would be the result. So that's another issue that can come up without a will.
Well, yeah. So it's not just the money aspect of it, but just even the relationships and the dynamics of the whole family. So, and especially in the first example you gave, right? Like realistically, you wouldn't want your spouse to have to struggle to have access to your own personal funds to be able to support your family at that point. And there could be delays with all that legal process and everything, and kind of struggles to even support the family right at that point.
Yeah, absolutely. And I mean, another consideration that I don't think occurs to people is what I mentioned. The courts will hold the funds for minors until they're 18. So once these children turn 18, the court is simply going to pay them the funds that have been held for them. But what if this is a substantial amount of money? Do you really want an 18-year-old to suddenly come into such a large amount of funds directly? I mean, if you had a will in place, you might have been able to set up something that said to hold funds in trust until they're a more mature age, potentially. But from a legal perspective, 18 is the minimum requirement. So that's
Mhm.
another aspect that comes up.
Well, the things that most of us would do at 18 with a large sum of money, right? We don't want to think about that, but all
No.
right. Well, how can you tell if you're working with a professional when you're actually getting your will in place?
So for me, having estate planning done, getting your will in place is about a lot more than just the document. So, I don't think that it's an appropriate approach to simply take instructions from somebody and then prepare their will according to that. I don't think that that does a good service to your client, because really you have to take a deep dive on your client's life. You have to really get to know and understand what their family dynamics are like, who's in the picture, what sort of considerations there are for the people they want to benefit on their death. In addition to that, you really have to do a lot of due diligence on what kind of assets people have, because the type of assets you have, the way that you own them, the value of them, the amount of liquidity that's available in your estate, these are all going to be factors that will guide the advice that you're going to give the client in terms of how to set things up for their estate. And you can't do that if you don't have those deep conversations. So I think really there are so many different scenarios that can occur depending on how you own your assets or who you own them with or what their values are, that you can't really give proper insight to somebody about the implications, for instance, of probate fees or whether probate will even be required on their death without having those conversations. So I think that's usually a big flag that you're getting the right advice, is if you're having those detailed conversations with your advisor.
Definitely. And now that you mention it, it's so true, because as a professional, you have seen how things could go wrong in the back end. And if you don't use that experience to actually ask the right questions and prepare the will accordingly so that you can avoid all those pitfalls, what's the whole point of even getting a will done at that point, right? And what you could get one done for free or something, but at that point, like, there's so many things that could go wrong. So
Yeah.
definitely.
No, there have, I mean, and based on my experience in the industry, part of it was working with a trust company. So
Mhm.
the reason that I'm very focused on the planning side of things is because I've been on the administration side of things and seen how things can go very wrong if documents are not prepared properly, or if there wasn't the due diligence on what was involved in the assets or the family to begin with. So it's definitely part of what fuels my passion in the industry to make sure people have things done properly. Yeah.
Okay, perfect. Well, thank you very much, Gosha. It was honestly a pleasure having you on, and thanks a lot for sharing all these kind of quick overview. But we'll definitely dive into it in the future sometime and try to get a little more insight into your industry itself for sure.
Yeah, no, that's great. And I'm hoping that we can do something in the future. There have been some recent changes in Ontario, and I think it'd be good to get that information out to the public as well. Thank you.
Perfect. Thanks a lot.